Hey class, today we're going to talk about defenses used in criminal legal cases. So we're going to begin with self-defense or the defense of others. Uh, so there's a couple elements that have to be met in uh, any self-defense case. And I should say, as I've been saying in these videos I've been making for you, um, I am speaking to a general state of the law. If you are um, you should research what the law is in whatever jurisdiction you live in so that you know how your specific state or jurisdiction um, applies these general principles. Okay, because what's true in Washington state might be totally different in California and dramatically different from Texas, but similar to Illinois, but completely different than how Vermont applies these criminal defenses. So check your local jurisdiction and the state statutes on these matters. So in general, self-defense or the defense of others, the attack must be unprovoked. Okay, so the attack against which you're defending must be unprovoked. You cannot have goaded somebody into attacking you, for example, and then harm them and seek shelter from a self-defense plea. The attack must threaten imminent death or injury to yourself or somebody else. You have to use objectively reasonable degree of force in response to the fear of imminent death or injury. And these objectively reasonable standards are all about what the jury thinks. Okay, when you hear a discussion of what is reasonable, as we've talked about in class, reasonableness is really a objective standard based kind of on what does the general population think about this, and the general population in a case is the jury. So an objectively reasonable degree of force. If someone's coming at you with fists and you pull out a gun, most juries are not going to find that to be a reasonable degree of force used in response to this fear of imminent death or injury. If there's a dramatic age difference between the defendant and the attacker, the assailant and the person defending themselves, again, relative arming might be a issue that comes up. So again, you got to look at the facts. You got to consider these kinds of issues before you can say, oh yeah, self-defense applies here. Remember to go through these elements and consider the facts as you find them. Defense of property is also an issue that might come up in a hypothetical on a test coming sometime soon. And when it comes down to defense of property, again, you got to check your jurisdiction because there are major differences in how states treat the defense of property with force. Okay, because the common law rule was you cannot defend property with deadly force. That was the rule that came to us from England. Since then, statutorily, most states have modified that rule. The two big broad categories are castle doctrine and stand your ground laws, okay, in terms of the defense of property. So castle doctrine, if someone has a reasonable belief that it's necessary to terminate another's unlawful attack or entry, they can use non-deadly force to terminate that other person's unlawful attack or entry onto their property or into their car or whatever. The deadly force can be used if the entry is made in a violent manner, or you have a reasonable belief that you're preventing the commission of a felony. Okay, now, for those of you that watched the previous video, you might recall that, burglary is a crime constituting the unlawful entry into a structure with the intent to commit some other crime, right? And so the very act of burglary might set up the situation in some castle doctrine states for the use of deadly force, because you might have a reasonable belief that you are preventing the commission of another felony. It's tricky, okay? Castle doctrine is, I suppose, a majority position amongst the states. Illinois is a castle doctrine state, for example. Stand your ground laws give people the right to use deadly force to defend their property against an unwarranted intrusion. And what it does is modify the rule that you have to retreat. And if you cannot retreat, then you can use deadly force in defense of your person, okay? This is about using deadly force to defend property, okay? Again, remember to look at what the law is in your jurisdiction to determine what is the allowable level of defense that one can assert in a given situation. It could be done simply by talking to the police, in the local jurisdiction to find out what is the law on defensive property. They will tell you. They will help you better understand what the state of the law is so you don't get in trouble. I mean, look, you ought to own property insurance, renter's insurance, and, it's there to replace property, okay? And it's there to replace property that's lost or stolen so that people don't get put into these situations where they have to make literally a life or death decision under pressure. They can rather just replace their stuff. And that seems to be it's a much safer way of dealing with theft. Your mileage may vary. Okay, infancy. Infancy is another defense asserted generally, and is generally asserted due to age of the criminal defendant. Again, check your jurisdiction, but in most areas, if a criminal defendant is under the age of 7 years, the courts will pretty uniformly say, look, this person can't form the requisite mens rea. They don't know the difference between right and wrong because they're a child, okay? Because they're so young that even if their action was constituted an illegal action, they didn't have the proper mental state, the requisite mental state, because they didn't know what they were doing was wrong. Again, a transitional gray area between the ages of 7 and 14. You're presumed not to be able to commit a crime due to that lack of requisite mens rea, but some states maintain a juvenile justice system, their own juvenile court system for people under the age of 18. Some states will punish kids as adults if they commit certain felonies with sufficient aggravating facts or aggravating conditions surrounding the case that they could charge them as an adult. So again, check your jurisdiction. Which brings us to insanity. Insanity pleas are really common on TV and in movies. They're not very common in real life, okay? And the reason is because they're really hard to prove, okay? It's really hard to prove up an insanity claim, okay? And also the uses of them can be limited by statute. Thus, you need to check your jurisdiction to find out how insanity pleas are treated. The basic idea of why an insanity defense exists is simply because a person with a mental disease or illness or disorder can't be convicted because they lack the requisite mens rea to commit a crime. They might have committed a felonious act, but if they didn't have the requisite mens rea, that intent or knowledge or reckless behavior or negligent state of mind, you can't charge them with a crime, okay? Now, what are the elements of insanity? It reads simple, but is a really tough proof question. So you either got to show that the defendant at the time didn't know what they were doing. They might have, you might be arguing that they, were in some sort of fugue, that they had a dissociative event and they weren't in touch with reality. They were hallucinating, or you could argue that the criminal defendant didn't know the difference between right and wrong at the time, so that they didn't know that what they were doing was wrong, or violative of society's rules. The way you use an insanity plea is to challenge, for example, the basis that the defendant's competent to stand trial, that this person shouldn't be tried, they can't be brought before a jury because they don't have the ability to defend themselves. Okay, they're not competent mentally. You could see insanity pleas used to argue, look, the defendant didn't have the capacity to commit a crime at the time of the criminal act. Or you could argue that it's a case of temporary insanity, that the defendant is sane now, but at the time of the crime, they were insane. Usually you see these in crimes of passion cases, spousal interactions, that kind of thing. And again, the reality is that the insanity plea is applied in less than 1% of federal cases. It's popularized through media. In reality, it doesn't get applied nearly as often as movie and TV shows would make you think it's applied. Entrapment is another defense. So if law enforcement induces or persuades someone who is otherwise innocent to commit a crime, that would be considered entrapment. Now, if the police merely provide the opportunity to commit a crime, and then the person chooses to commit that crime, that's not entrapment. That person made a decision to commit a crime. But by merely presenting the opportunity to commit a crime, do you want to buy these drugs? Do you want to help me steal this car? Do you want me to hurt that other person really badly because they made you upset? If that person in any of those cases says, yeah, let's do it, they can't subsequently necessarily assert a successful entrapment defense because they made the conscious decision to commit the crime. Entrapment is also a difficult one to prove because the defendant has to show that they would not have otherwise committed the crime if not for the inducement of the police officer. So again, it's kind of like trying to prove a negative, right? You gotta show that you wouldn't have otherwise done something that you did, but for the police's involvement in making you do it. A lot of jurisdictions assert that entrapment can never be used in either a murder case or a rape case, an aggravated sexual assault case. So again, check jurisdiction for what the state that you live in, how they apply these kind of defenses. Necessity is another defense that can be used against otherwise criminal actions. And the argument basically is, look, or the defense is basically, look, I was compelled to react to an unavoidable situation in order to protect my life and the lives of others. Okay. So, for example, a prisoner is in a prison that catches on fire. And so the prisoner has the opportunity to flee the building because it's burning down. And if they stay in the building, they could conceivably die. So they remove themselves from the building, And then the question is, okay, now do they stand around outside the prison or do they keep going? Okay, because the necessity might be applied just to that limited situation or removing yourself from the building. But then if they tried to escape prison altogether, the necessity defense becomes a little more attenuated, let's say. One of the interesting wrinkles with the necessity defense is that in general, you got to lack criminal intent, and thus your goal is to prevent harm coming to you or others. Okay, maybe you might commit one crime to prevent another. So, for example, pulling a fire alarm might be a misdemeanor, but if you're pulling that fire alarm to alert other people to some other danger, that might be, a defense against the misdemeanor pulling the fire alarm. Again, necessity's never going to be able to be asserted against homicide. It's never necessary to kill somebody else, because if you are acting that, there's a different defense to assert, right? Self-defense or the defense of others. Okay, so you're not calling a self-defense case necessity. A self-defense case is a self-defense case, okay, against a homicide charge. Okay, the last defense is duress, okay? And duress is pretty straightforward. I mean, it's when someone says, look, I committed a criminal act, but that's because I was under coercion or a threat of immediate danger to myself or to a loved one, that I had to commit this crime to save myself or save someone else. And essentially, you got to demonstrate that you had no free will to act other than to commit the crime. Okay, somebody had a gun to your head, metaphorically or literally, and thus you acted. Okay, so, and this duress also, as I mentioned, applies if a close family member is being threatened. So, but again, most jurisdictions are not going to allow you to claim duress as a defense against a homicide. Okay, so these are common defenses. I'm going to end with the same thing I started with. Always check the jurisdictions, because these are general rules that I'm laying out for you. Always check the law of the jurisdiction that you find yourself in. I'll talk to you soon in class, and otherwise, have a great rest of your day.